This video is one in a series of videos on special education due process developed by the Office for Dispute Resolution, or ODR, and the Pennsylvania Special Education Hearing Officers. The purpose of these videos is to give you an overview of what to expect if you are involved in a special education due process hearing. Before we begin, please be aware that this video series addresses special education due process hearings filed under the Individuals with Disabilities Education Act, or IDEA. These are the most common types of due process hearings. If your hearing is about gifted education, Section 504, or early intervention, there may be some minor differences in your hearing procedures, especially as to resolution meetings and timelines. However, these videos should still be helpful in getting prepared for any of these hearings. For more detailed information on gifted education or Section 504, please call the Bureau of Special Education's Consult Line. For more information on due process, please visit the ODR website. Contact information is available here and at the end of each video. For additional information regarding early intervention, please refer to the Procedural Safeguards Notice. Video 3. The Hearing.
Hello, I'm Hearing Officer Brian Ford. This is the third in a series of videos on special education due process developed by the Office for Dispute Resolution and the Pennsylvania Special Education Hearing Officers. Each video in the series focuses on a different aspect of the hearing process. The series is presented in a logical sequence from pre-hearing concerns to preparing for the hearing to the hearing itself. This third video addresses the due process hearing itself. We've included a general overview of the hearing setting and the hearing process, the different parts of the hearing and the typical order that they occur, and what happens once the hearing is over. In each video, we will use the term school district to refer to any local educational agency, including a school district, intermediate unit, or charter school. Overview of the hearing. Let's start by looking at the hearing room and participants. The due process hearings are typically held in conference rooms in one of the school district buildings. It's important to keep in mind that the hearing is not a meeting, but it is a formal procedure that is similar to a court proceeding. Present at the hearing will be the parents, any supporters that the parents wish to attend, school district administrators, the attorney for the parents if they are represented, the attorney for the school district, witnesses, a court reporter, and the hearing officer. The parents may decide to have the student attend. The parents also decide whether the hearing will be open to the public or closed to the public, such that only the people who are necessary are permitted to attend. The hearing officer will ask the parents to make that decision at the beginning of the hearing. The court reporter will swear in the witnesses as they are called to testify, so that the testimony is under oath. The court reporter will also make a record of the hearing. It is important to remember that everyone must speak one at a time so that the court reporter can take everything down. The hearing officer will remind everyone about this rule and will also manage the hearing and the participants to ensure that a clear record is made and that everyone shows respect for the process. The court reporter will provide a copy of the transcript to the parties after the hearing ends. The parents have the right to a free copy of the transcript, but if the parents are represented by an attorney, usually he or she gets that free copy. Parts of the hearing. The hearing begins with opening remarks by the hearing officer. Then, the parties will have a chance to make an opening statement. Opening statements are not evidence, but they allow the parties to give an outline or summary of what the issues are and what the parties believe the evidence will show. Opening statements are the way each party introduces their side of the story. On the ODR website, there is a sample format of an opening statement in the Guide for Parents titled Understanding Special Education Due Process Hearing. Keep in mind that in general, opening statements need not be long and detailed, but since the opening statements let the hearing officer know what the issues are, it's important to include all of them in your opening statement.
Good morning. My name is Beth Jones, and my son Connor is in the 5th grade at West Elementary School within the school district. Connor has an IEP for reading, and things were going well until last year. Starting in about October, his progress report on his reading goals showed that, and I think the witnesses you will hear from and the exhibits you will see will show you that Connor really needs these additional services that we are asking for. Thank you.
After the opening statements, there will be plenty of time to present evidence to the hearing officer through the witnesses and exhibits. The party who filed the due process complaint usually presents evidence first. That party also has the burden of proof, or the burden of persuading the hearing officer that their position is correct. As discussed in the second video, evidence generally takes two forms: witness testimony and exhibits. Witnesses will answer questions by both parties. Witnesses are questioned first by the party who calls them on direct examination.
Mrs. Green, what were Connor's scores on that reading test at the beginning of this school year?
Connor scored in the below basic range.
And did that score concern you?
After the party who called the witness finishes the questions on direct examination, the other party may ask questions of the witness on cross-examination.
Did Connor's reading scores on that reading test improve from the prior school year?
Yes, we did give that same test at the beginning of 4th grade, and it did improve.
There may be another round of questioning called redirect examination and re-cross-examination, and the hearing officer may also ask questions of the witness. The witness may also be asked to refer to exhibits during their testimony. It is usually not necessary to have anyone read aloud from exhibits, since the hearing officer will read the exhibits himself or herself. But witnesses identify exhibits and testify as to how those exhibits came to be relevant to the case.
Can you please identify S5 in your binder?
Yes, it is Connor's 3rd quarter progress report.
And could you please turn to page 4 of that document and explain what it shows?
It shows that Connor improved his oral reading fluency since the 2nd quarter.
After the party who filed the complaint presents all of their evidence, the other party will have the same opportunity to call witnesses and present exhibits. Sometimes the order of the hearing must be changed to accommodate witnesses' schedules or to make the hearing more efficient. But rest assured that the hearing officer will be able to give proper consideration to all of the evidence regardless of the order in which it is presented. Parties may raise objections to witnesses and exhibits presented by the other party. For example, a party might object to a witness whose testimony is not relevant to the issues in the case, or whose testimony merely repeats what other witnesses have already said.
How did Connor do on that test compared to the other kids in the class?
Objection. This has no relevance to Connor's individualized education program.
I agree without objection. Please do not answer that question.
How did Connor's score compare to the scores in the 3rd grade?
Objection. This has no relevance to Connor's 5th grade education program.
I don't agree. I think it's relevant. Please do answer that question.
We are not able to explain the rules of evidence in this video series, but you may find the guide for parents titled Understanding Special Education Due Process Hearing helpful in explaining some common objections. After all of the evidence is presented, the hearing officer will ask the parties to give closing statements. Like opening statements, a closing statement is not evidence. It is a summary of the issues and the evidence in support of each party's position.
Hearing officer, I think the evidence showed that the reading program the district's using for Connor is just not working. We are asking for all of these additional services in his IEP.
Hearing officer, you heard Mrs. Green explain how Connor has made progress. In conclusion, the school district asks that you find that his education program was appropriate and that no relief be rewarded.
The closing statement is the final chance to tell the hearing officer why each party should receive the relief they requested. The hearing officer will decide whether the closing statement should be oral or written.
Decorum in the hearing. Hello, I'm Hearing Officer Linda Valentini. A due process hearing is a formal proceeding based upon principles of fairness and respect. Hearing officers recognize that they can be emotional as well. However, the hearing officer will require that everyone in the room be respectful of the process and of everyone else who is involved. In the next video, I will provide some practical guidance on being a participant in a due process hearing. Hearing sessions. Hearing officers will try to complete the hearing in one day. However, many times due process hearings require more than one session. If that happens, the hearing officer will work with the parties to find a new date to hold another session that is convenient for everyone, but within a reasonable amount of time so that the process does not become protracted.
Here is a frequently asked question. What if there is an emergency on the morning of a hearing?
Hearing officers understand that sometimes emergencies happen. You should contact the hearing officer as soon as possible to explain the situation. After the hearing. In the first video, we explained the IDEA timelines, including that each case has a decision due date. Throughout the hearing process, there is always a decision due date attached to the case. That date can be extended if a party requests an extension. The decision due date is often extended when there are requests to reschedule a hearing session or the hearing requires more than one session. At the end of the final hearing session, the hearing officer will confirm the final decision due date. By that date, the hearing officer will send a written decision to the school district attorney and the parent's attorney, or the parents directly if they are representing themselves. The written decision includes findings of fact and conclusions of law and will address all the issues from the hearing. Appeals timelines are sent along with the decision, telling the parties when an appeal must be filed if they disagree with the hearing officer's decision. Remember that the hearing officer's decision must be based on the evidence in the case and the law that applies. The decision can't be based on emotions or on matters that were not made part of the evidence in the case. One last word. As always, if you have questions or concerns about your due process hearing, do not hesitate to contact the hearing officer by sending an email message with a copy to the other side or by asking to schedule a conference call. The hearing officer understands that many people, especially parents representing themselves, are unfamiliar with the legal process. Hearing officers are always ready to answer questions and to help clarify anything that is confusing. Hearing officers cannot, however, give legal advice. Summary. In this third video in this series, we talked about the actual hearing with an overview, the parts of the hearing, and what happens after the hearing. The fourth video in the series is based on a presentation I have done several times that offers some practical tips and suggestions that can apply to anyone who is facing a due process hearing. There is also a video of a mock due process hearing available on the ODR website.
For more information, please contact the Consult Line or the Office for Dispute Resolution.